Makebi Zulu exposes government's illegal bill resurrection explosive petition filed. Tonight, Makebi Zulu has thrown a political grenade into Zambia's legal and political arena, filing a petition that claims Bill number 7, once declared dead, has mysteriously returned, and the government is behind it. Why is Bill 7 suddenly back? Who revived it? And what exactly does Makebi's explosive petition reveal, details the public was never supposed to see? Stay with us, this story could reshape the debate on Zambia's democracy. Good day, viewers. Welcome to another edition of the InspirAfrica Official. I'm Nakash. Well, what a week it's been in Zambian politics. The rains have started, the holidays are approaching, but in Lusaka, the storm clouds gathering over the Constitutional Court are far more ominous than any weather system. Today, we lead with a story that strikes at the very heart of constitutional democracy in Zambia. A story about power, defiance, and one lawyer's explosive stand against what he calls governmental contempt of the highest court in the land. Picture this, a bill, declared legally dead by the Constitutional Court. Pronounced unconstitutional. Buried by judicial decree. And yet, like something from a political horror story, that same bill is being resurrected, dusted off, and marched back into Parliament as if the court's judgment was merely a suggestion rather than binding law. Can a government simply ignore a constitutional court ruling? Can the executive and parliament collude to revive legislation that the judiciary has already declared null and void? What happens when those sworn to uphold the Constitution become its most brazen violators? And here's where it gets even more dramatic. One man has decided to stand in the breach. Constitutional lawyer and Patriotic Front presidential candidate Makebi Zulu has filed an explosive petition that accuses the Hichilema administration of nothing less than constitutional sabotage. But the questions run deeper, don't they? If the government succeeds in resurrecting Bill number 7, what does that say about the rule of law in Zambia? What precedent does it set when court judgments become optional, when constitutional boundaries are treated as mere inconveniences to political ambition? Is this about constitutional reform, or is it about power consolidation? Is this about serving the people, or is it about ensuring the ruling party's grip on governance? And if the Constitutional Court's word can be so casually dismissed, then whose authority remains in this nation? The stakes couldn't be higher. Because what we're witnessing isn't just a legal battle over parliamentary procedure. This is a defining moment that will determine whether Zambia is governed by the Constitution, or whether the Constitution is governed by those who happen to hold power. Factual foundation, background and timeline. The revelation came to light on December 5, 2025, when Honorable Makebi Zulu, constitutional lawyer and declared presidential candidate for the Patriotic Front, filed a fresh petition before the Constitutional Court of Zambia. The petition directly challenges President Hakainde Hichilema's administration, naming the Attorney General as respondent. But to understand the full weight of this moment, we must go back 6 months. In March 2025, the Hichilema government announced its intention to amend Zambia's constitution. The vehicle for this change would be the Constitution Amendment Bill number 7 of 2025. Almost immediately, opposition MPs Munir Zulu and Celestine Mukandila challenged the process, arguing before the Constitutional Court that the bill was being rushed through without adequate public consultation, a requirement enshrined in Article 79 of the Constitution. By June 26, 2025, sensing the legal storm approaching, President Hichilema instructed his Justice Minister to defer Bill 7. It appeared, for a moment, that the government might be backing down. But the very next day, June 27, 2025, the Constitutional Court delivered its judgment in the case of Munir Zulu and Celestine Mukandila versus the Attorney General. The ruling was devastating for the government. The court, in a 4-3 majority decision, declared that the entire legislative process behind Bill 7 was unconstitutional. The judges held that the Constitution could not be amended without transparent processes, full public participation, and an independent committee of experts leading the consultations. The court's language was unambiguous. Bill 7 was null and void ab initio, meaning it was void from the beginning, as if it had never legally existed. The Law Association of Zambia weighed in shortly after, writing to the Attorney General demanding that the presidency acknowledge Bill 7 as dead, not merely deferred. Their letter, dated July 29, 2025, was crystal clear: the bill was legally non-existent and any attempt to revive it would violate constitutional supremacy. But the government had other plans. In October 2025, after sustained pressure from civil society, President Hichilema established a 25-member technical committee on constitutional amendments. This committee was tasked with conducting nationwide consultations and drafting a new constitutional amendment proposal. Here's where the timeline becomes critical. According to Makebi Zulu's petition, this technical committee completed its consultations and drafting work in just 34 days. 34 days to consult 19 million Zambians across 10 provinces on changes to their supreme law. Makebi Zulu describes this timeframe as patently unreasonable and designed to create nothing more than an illusion of public participation. Then came December 2, 2025. The Minister of Justice approached Parliament requesting the reinstatement of Bill 7. The Deputy Speaker directed the relevant parliamentary committee to begin scrutinizing the bill. But here's the smoking gun: no new bill had been gazetted. No official legislative notice had been published. They were attempting to resuscitate the very same Bill 7 that the Constitutional Court had already killed. On December 4, 2025, the government announced through acting leader of government business Ambrose Lafuma that Bill 7 would go for its second reading in Parliament on December 15, 2025. That's when Makebi Zulu struck. On December 5, 2025, he filed his petition. And this time, he wasn't just asking questions. He was demanding answers, and more importantly, demanding action from the courts to stop what he calls a constitutional coup in progress. Direct evidence. Let's hear from the key players in their own words, because what they say reveals everything about this constitutional drama. Makebi Zulu's petition, filed December 5 before the Constitutional Court, pulls no punches. The document reads, and I quote, "By reinstating a dead bill, the respondent is circumventing Article 79 of the Constitution and corrupting the lawful process of constitutional amendment." The petition goes on to state that the government is attempting to render the court's binding judgment nugatory, essentially making the court's decision meaningless through deliberate defiance. On the technical committee's rushed consultations, the petition describes the 34-day timeframe as designed merely to create an illusion of public participation and argues that it was incapable of meeting the constitutional threshold of wide and effective public consultation. Perhaps most damningly, the petition argues, the government acted in bad faith by attempting to retrospectively fix the fatal defects of Bill No. 7 through this hurried process despite the court's clear instruction that any new attempt at constitutional amendment must begin de novo, from scratch. In an open letter dated December 3, 2025, addressed directly to President Hichilema, Makebi Zulu wrote, "This letter is a firm and principled demand that your government immediately ceases all efforts to proceed with the Constitution Amendment Bill No. 7 of 2025, in order to protect Zambia's democracy, uphold the authority of the Constitution, and honor the clear will of the people." He continued, "The Constitutional Court has already pronounced that the process leading to the bill did not meet the threshold of wide and meaningful public consultation required by Article 79, rendering it inconsistent with the Constitution and therefore void." And then this pointed statement, continuing with, "Repackaging, or reintroducing Bill 7 in defiance of this ruling would signal contempt for judicial authority and erode the rule of law that your administration pledged to uphold." Makebi Zulu's letter warned, the Constitution belongs to the people of Zambia, not to any temporary majority in parliament or any sitting government. History will judge harshly any leadership that chooses to ignore a clear constitutional court ruling and the unmistakable voice of citizens. The Law Association of Zambia, in their July letter to the Attorney General, was equally forceful. They wrote, "We write to express our serious concern regarding the President's repeated public characterization of the Constitution Amendment Bill No. 7 of 2025 as deferred, rather than null and void ab initio, which is the clear effect of the Constitutional Court's judgment." LAZ explained the legal position clearly. On June 26, 2025, Parliament deferred Bill No. 7 on the assumption that it had been lawfully introduced. However, on June 27, 2025, the Constitutional Court held that the entire legislative process was unconstitutional, null and void ab initio, and of no legal effect whatsoever. Their letter requested that the Attorney General advise the Presidency to cease any commentary inconsistent with the Court's judgment and to acknowledge unequivocally that Bill No. 7 is null and void, having been declared unconstitutional. In a more recent statement dated December 4, 2025, LAZ President Lungisani Zulu reiterated, the Constitutional Court declared that the decision by government to initiate a constitution amendment process culminating into Bill 7 before undertaking wide consultations with the people goes against the spirit of Articles 1, 2, 5, 7, 8, 9, 61, 90, 91, and 92 of the Constitution. LAZ added, it was the court's considered position that the initiation of the Constitution amendment process must come from the people and there should be a tangible and visible process of broad-based consultations to support legitimate amendments to the Constitution. And in a separate development that underscores the legal chaos surrounding Bill 7, lawyers Celestine Mukandila and Munir Zulu, the original petitioners who successfully challenged the bill, have now commenced contempt of court proceedings against Attorney General Mololo Kabesha, Speaker Nelly Muti, and all members of parliament for what they describe as presiding over and participating in proceedings on a bill the Constitutional Court has ruled unconstitutional. One news analysis captured the gravity of this moment. This is not common in our history. It is the law waking up and demanding respect in its loudest possible voice. The analysis continued, the summons served on parliament are clear. They reference the earlier ruling where the court held that constitutional amendments cannot be initiated without broad public consultation and must originate from an independent expert process. By all established authority, Bill 7 is null. It is void. It is dead in law. Yet Parliament attempted to breathe life into a dead bill. Deeper analysis. So what are we really looking at here? This isn't just a procedural dispute between lawyers and politicians. This is a fundamental clash over the very nature of constitutional governance in Zambia. At its core, Makebi Zulu's petition raises a question that transcends Bill 7 itself. Can a government simply ignore a constitutional court judgment it doesn't like? The answer should be simple, absolutely not. The Constitutional Court's decisions are binding on all branches of government, including the executive and parliament. Article 128(4) of the Zambian Constitution makes this crystal clear. But here we have a government that appears to be treating a court ruling as a mere inconvenience. By attempting to resurrect Bill 7 without starting the constitutional amendment process from scratch, as the court explicitly ordered, the administration is essentially saying that judicial authority is optional, that it applies only when convenient to those in power. This has massive implications for the rule of law. If the government can circumvent a constitutional court ruling on constitutional amendments, what's to stop it from ignoring court rulings on elections, on human rights, on any matter where the judiciary stands between power and its exercise? The rushed 34-day consultation process reveals another disturbing truth. This was never about genuine public participation. Constitutional reform is supposed to be a solemn, deliberate process. It's about changing the fundamental rules by which a nation governs itself. Yet the technical committee supposedly consulted all provinces, gathered input, drafted amendments, and produced a final document in barely over a month. For context, the original 2016 constitutional amendment process took years of consultation. Legal experts have described this as attempting to fix Bill 7 through procedural window dressing while maintaining its substantive content. It's like repainting a car that's been declared unfit for the road and hoping no one notices the engine is still broken. Various stakeholders have weighed in with concern. Civil society organizations, including the Oasis Forum, have filed their own petitions challenging the legitimacy of the technical committee. The LCK Freedom Foundation has argued that the committee lacked the independence required for genuine constitutional reform, being appointed directly by the president whose political interests are served by the amendments. Professional bodies like the Law Association of Zambia have been remarkably vocal, which is significant. LAZ rarely takes such strong public positions on political matters, but they've recognized that what's at stake here transcends politics. This is about whether Zambia will be governed by law or by the whims of whoever holds power. The substantive content of Bill 7 has also raised alarm bells. Critics, including members of parliament and governance advocates, have described the bill as poisonous to democracy. The proposed changes would expand parliament while centralizing power, tamper with by-elections, and weaken local government structures. Opposition figures argue these changes aren't about improving governance, they're about entrenching the ruling party's power. Makebi Zulu himself has called out provisions that risk upsetting the balance of power between the executive and the legislature, potentially weakening institutional independence and eroding accountability. There's also a curious political backdrop to all of this that can't be ignored. Makebi Zulu served as the lawyer for the late former President Edgar Chagwa Lungu, who died in June 2025 and whose burial remains frozen in South African courts due to legal challenges initiated by the current government. Some political observers see Makebi Zulu's aggressive stance against the Hichilema administration as part of a broader political confrontation rooted in the bitter rivalry between the Patriotic Front and the UPND. But regardless of political motivations, the legal arguments stand on their own merit. Either the Constitutional Court's ruling matters, or it doesn't. Either the Constitution is supreme, or it's just paper. The timing is also instructive. The government has scheduled Bill 7's second reading for December 15, 2025, just 10 days after Makebi Zulu's petition. This suggests either remarkable confidence that the courts will rule in their favor, or a willingness to proceed regardless of legal challenges. Neither option bodes well for constitutional governance. What makes this particularly explosive is the remedy Makebi Zulu is seeking. He's not just asking the court to declare Bill 7 unconstitutional again. He wants a declaration that Bill 7 is null and void with no legal force whatsoever. A declaration that the technical committee's consultations were insufficient and unconstitutional. An order of stay restraining Parliament, the Speaker, and all public officers from debating, reintroducing, or considering Bill 7. An order compelling the government to restart the entire process from scratch with genuine consultation, proper drafting, proper gazetting, and a completely new bill. If the court grants these remedies, it would be one of the most dramatic assertions of judicial authority over the political branches in Zambian history. It would establish that constitutional supremacy isn't negotiable, that court rulings aren't suggestions. But if the court refuses, or if the government proceeds despite an adverse ruling, then Zambia enters dangerous constitutional territory where the separation of powers collapses and might becomes right. Thank you so much for watching today's coverage of this explosive constitutional confrontation. This is a story that will define Zambia's democratic trajectory for years to come. The central question remains before us all: can a president and parliament revive a bill that the Constitutional Court has already declared dead? The Constitutional Court will soon have to answer that question, and their answer will echo far beyond Bill 7 itself. We want to hear from you. What do you think about this situation? Should the government be allowed to proceed with Bill 7 despite the court's earlier ruling? Is Makebi Zulu right to take such aggressive legal action, or is this just political grandstanding? Drop your thoughts in the comments below. Let's have a respectful but robust discussion about the rule of law and constitutional governance in Zambia. We'll be following this story closely as it develops. The Constitutional Court hearings on Makebi Zulu's petition could happen any day now, and you can be sure we'll bring you comprehensive coverage of every development. If you found this documentary informative, please hit the like button and subscribe to the InspirAfrica official channel. Turn on notifications so you don't miss our next report. Until then, I'm Nakash, and I'll see you tomorrow with more news, more analysis, and more truth. Take care, and may the rule of law prevail.